Hello, my name is Ricky Caboverde. This short presentation is in partial fulfillment for the course Foundations of Library and Information Science, LIS 60600. Today I will be speaking on the topic of fair use and its implications in the academic library. However, this presentation does not set out to be exhaustive, as 10 minutes is too short a time necessary to properly carry out such a task. But rather I will focus on the basics of fair use in copyright law, as well as some areas in the academic library we see fair use active. Copyright law has existed long before the Founding Fathers wrote the Constitution. In England, the Licensing Act of 1662 was created to protect intellectual property rights for a set period of time before works would enter public domain. The idea was to encourage original enterprise by allowing creators and rights holders ample time to profit from their works and control the use of their information for a time, but this was only for a period of 14 years, after which a copyright holder could renew only once. This gave a limit to the monopoly, leaving open a future possibility for use by others to create new knowledge. When drafting the Constitution for their new government, the Founding Fathers likewise granted these rights through the Copyright Act of 1790. But in a revision of this act nearly 200 years later, the length of the term for these rights extended from two possible terms of 14 years to the life of the author plus 50 years, or 75 years total for works made for hire. It also codified fair use in Section 107 as a provision for use by reproduction of copyrighted works for the purposes of criticism, comment, news reporting, teaching, scholarship, or research. Under copyright law, there are legal ramifications if a publisher creates copies of another's work, or publishes information belonging to a copyright holder without their consent or acknowledgement. But not always is the case so clearly black and white. Is there ever a case for fair use without consent? What happens in cases where borrowed information is used with a different or transformative purpose in mind? Or if the borrower claims to create a new work for a different use? In 1841, Charles Folsom of Folsom, Wells and Thurston sued publisher and bookseller Marsh, Capon and Lyon for piracy. Folsom had published a 12-volume work by Jared Sparks titled The Writings of George Washington. In it, Sparks included much of George Washington's letters, personal correspondences, addresses, and the like, as well as a biography and notes on the former president. Marsh, on the other hand, published a 2-volume biographical work by Reverend Charles Upham titled The Life of General George Washington. This work was mainly a posthumous autobiographical work using President Washington's own words through a collection of his writings, and this is where Folsom had issue. Upham's biography contains several hundred pages of letters from Sparks's publication, to which Sparks owned the rights. Upham claimed this was merely an abridgment and not an infringement upon his copyright. However, after much consideration, Justice Joseph Story, Circuit Court Judge for the District of Massachusetts, with reluctance ruled in favor of the plaintiffs, observing that Upham's work entirely depended upon the letters, and thus intended to supersede the original, rather than offer a new work or criticism, the basis for true fair abridgment. He stated that regardless of intention, Upham had indeed infringed upon the other's copyright. Although some have contended that this ruling was more a redefining of infringement than a case of fair use, Folsom v. Marsh was inarguably an important case for the doctrine of fair use, as the ruling set forth ideas still used by judges to this day when determining whether a new work has standing on the basis of fair use. In his ruling, Justice Story stated one must look to the nature and object of the selections made, the quantity and value of the materials used, and the degree in which the use may prejudice the sale or diminish the profits or supersede the object of the original work. This observation was pivotal in forming 4 factors of consideration for fair use. The first factor is the purpose and character of the use, whether the secondary use is for commercial or nonprofit educational purposes. In a Harvard Law Review article on working towards a fair use standard, Judge Pierre Laval noted there should be a transformative nature in the new work. He said, "A quotation of copyrighted material that merely repackages or republishes the original is unlikely to pass the test. He goes on to explain that if, on the other hand, the secondary use adds value to the original, if the quoted matter is used as raw material, transformed in the creation of new information, new aesthetics, new insights, and understandings, this is the very type of activity that the fair use doctrine intends to protect for the enrichment of society. Although there is great leeway for a defense based on educational purposes, the other three factors also weigh in the final decision. The second factor considers the nature of the work being used. Was the original work ever intended for publication? What was its creator's intention? If the original work is available commercially, is it specifically educational in purpose? Facts and ideas cannot be copyrighted. Thus, copyrighted works that are factual in nature have greater availability for use under fair use, but artistic or fictional works are less so. This second factor seeks to protect the interests of the creator, and especially the right to decide how the information is first published. The third factor looks at the extent and substance used from the original. Fair use requires that the secondary use borrow the least amount possible to achieve the purpose of the new work, and that it not contain too much information significantly important from the original so as to supersede it. Not that the key part of a work, or the cherry on top, is entirely off limits, but generally if it is not absolutely necessary, then it is not fair use. Finally, the last factor considers what impact the new work has on the market of the copyrighted work. Does the use of the copyrighted material create greater social benefit than loss to the copyright holder? Does it affect the possibility of profiting from a potential market for the copyright holder? Does it rob the original work in any way? This may seem simple, but it is actually quite complicated, and especially so in cases where the market effect is difficult to ascertain. Furthermore, not every secondary work that greatly impairs the market of a copyrighted work is in violation of fair use. These four factors can be concisely whittled down to just two main concerns: that of the transformative nature of the work, if it has created something new for a different use, and the appropriateness of the amount used. As you can see, not only are these factors interrelated, but they are also somewhat vague. Yet this was not done without purpose, as fair use is normally applied in cases where copyright law is not specific. The Association of Research Libraries 2012 publication, Code of Best Practices for Fair Use, rightly notes that fair use is flexible rather than a set formula. We will now briefly see areas in the academic library in which fair use is practical. The ARL Code of Best Practices for Fair Use states that academic libraries are for the enablement of teaching, learning, and research. They not only serve staff, faculty, and students, but also researchers, lawyers, and the general public. In order to meet the many needs of these patrons, libraries rely on fair use. The Copyright Act favors goals towards education and intellectual freedom, and has included many provisions for libraries. Section 108 includes permissions for copying or reproducing material, as well as archiving. Protections under this provision can be observed any day in an academic library when students make copies for their research papers, or when faculty members make copies of book chapters for their classrooms or perhaps in ongoing research, or even when photocopies of journal articles are requested through an interlibrary loan. This particular section was brought up against HathiTrust by the Authors Guild. Fortunately, HathiTrust was found in compliance and won in a major decision for all libraries. Section 110 allows rights for performances or displays of works in a classroom setting. However, there are restrictions for distance learning. Under this section, all works are available for display except for non-dramatic musical and literary works. This section is important in the classroom, where a selection of music or perhaps a film would be highly instrumental in aiding critique and dialogue. Section 121 gives libraries the right to make print material available for print-disabled patrons. This section was also brought up in the HathiTrust case in conjunction with Section 108. Section 121 protects disabled patrons from discrimination and helps promote the librarian core values of access and intellectual freedom. Section 504(c)(2) allows the court to remit statutory damages for nonprofit libraries and archives if they have acted in good faith. Not exactly a get-out-of-jail-free card, but it is incredibly important for academic libraries as costs for infringing upon a copyright can be extremely costly when damages awarded and attorney fees are added up. The provisions state that as long as the employee or agent of the library acted in good faith, unaware of any violations taking place, then damages may be remitted to none at all. Knowing what rights are given under fair use is very important, as ARL noted that many librarians overestimate the strictures of copyright law when considering their rights through fair use. However, fair use is a right and not an obligation. Libraries may forego exercising this right, and for the sake of ease, precaution, and in good faith, may choose instead to license or seek permission for the use of copyrighted material. As information professionals, librarians should be as informed as possible in this technology-driven age, especially when these laws are able to further our mission. In fact, this whole presentation is made possible thanks to fair use. And this concludes my presentation. Listed are references for more information on fair use. Thanks so much for watching.